The accused persons in the Masaka Machete murders include legislators Muhammed Ssegirinya for Kawempe North, Alan Sewanyana for Machindeo West, Maiko Serwadda, Jackson Kanyike, John Mugerwa, and Bulu Wamala. The case has resumed for pre-trial hearing at the International War Crimes Division Court before Judge Alice Muhanji Kauka. But the absence of legislator Muhammed Ssegirinya, who is still receiving treatment in Amsterdam, hindered the hearing of the case. Counsel for the accused Samuel Muyizi asked the court to adjourn the case.
It is not possible. Actually, the hospital had left it open-ended. But in my anticipation as a practitioner, certainty had to certainty to at least 30 days. Those are the normal adjournments. I believe, especially from the information, further information we obtained, even 30 days will not be a normal adjournment, as I had intimated as counsel. So anything beyond 30 days would suffice if we are to be serious about coming here and proceeding. If we are to proceed, it can't be 2 weeks.
Either terminates the proceedings against Honorable Ssegirinya, or advises the prosecution, my lord, to remove Honorable Ssegirinya off the charge sheet or the indictment in order to proceed with the hearing of this matter. I so carry.
I associate myself with the submission of Counsel to James Sima. In as much as my client, Mr. Mugerwa John, is concerned, my lord, the client has applied for bail before you or before this honorable court 3 times. And among the reasons this honorable court is being forwarding for perhaps why he may not be out is that this honorable court will expedite this case in first month. But my lord, to date, the same grounds that he pleaded or he averred to in his applications that the honorable court will not be able to hear the matter expeditiously are the ones we are facing today, Your Honor. So it's also my prayer, Your Honor, that this honorable court adjourns this matter for the last time and orders the prosecution find a way of dealing with the issue of Honorable Ssegirinya, Your Honor, because our client's fear is that this is going to become the trend. And I bring to the attention of this honorable court the fact that, Your Honor, my client specifically has dependents, has children, has wife, Your Honor. So, the honorable court keeping on to adjourn without hearing the matter infringes on all the rights of my client, Your Honor. So it's my prayer that adjournment suffices, and the next time we are able to proceed and hear the matter. This hope.
My lord, prosecution has always wished Mr. Honorable Ssegirinya.
Sorry?
Prosecution has always wished Honorable Ssegirinya quick recovery. And we are aware that he's in that state. They have, on top of that, provided some communication from Aga Khan Hospital, Nairobi. In which they promised to provide further medical guidance thereafter. That letter. On that basis, it will be inhuman of us to object to the adjournment. Because you cannot prosecute an ill person. My Lord, however, my brother Tuyamusima suggested that this should be a short adjournment. It is our submission that given the fact that Honorable Ssegirinya is sick, and we have no control over that state, then there is no call for a short adjournment. But I appreciate the fact that he has his clients under detention. But rationally, there is no need for a short adjournment. It should be a normal adjournment where we don't have to come back and again go back to the same thing. At least should be a solution where we probably have new developments. Because if we put it like in 2 weeks' time, then we'll still virtually come back with the same information. Because now his brother has just informed the court that they just removed the machines from him. So we don't know what will happen tomorrow. So I would think we have a longer adjournment.
Longer adjournment is how long?
I have taken note of the fact that Honorable Ssegirinya is critically ill, as per the documentation that was availed in the court today, especially the letter that came from Aga Khan University Hospital, which is addressed to the Clerk to Parliament, and it was dated 30th January 2024. In that letter, it is indicated that he was admitted on the 23rd of December 2023, and he remains critically ill in the hospital, and the anticipated date for his discharge is at least 30 days from the date of the letter. This would mean on or about the 3rd of March 2024. However, I have also listened to his surety, who informed the court that as at the 15th of February, he was, though out of coma, he had not fully stabilized. I am mindful of the fact that other accused persons are on remand, and this matter had been adjourned several times on account of the ill health of Honorable Ssegirinya. However, ill health is beyond anybody's control, and though it is absurd that this matter has to be adjourned, I am mindful that the other persons are on remand, but we are constrained. We have to have this matter adjourned.
During the same proceedings, the accused Muhammed Ssegirinya raised concern over his prolonged torture application. He had earlier filed before this court.
Nakugamba nti COVID yamulemesa okujja ku apa ossa asobole okusayininga ku application ye. Kati tuli myaka ebiri. application torture kujjanga mu kooti zinatulugunyizibwa mu misango gye simanyi ku babaka besimanyi besirabangako naye nateeka ensonga zange mu application torture zonna nenzirambika kooti eno esobole okumpuliriza eri empogowekanya okutuusa kati kanso kubuuza application torture kiki ekyagigaana okugenda mu kooti wano ng'ate covid yagwawo ng'ate eddembe lyange lityoboolwa nvunaanibwa emisango gyesizangako ku bantu besirabangako kubano bonna sirina bwe mmanyi mbalabira mu kooti wano batujja mbadde nsaba kooti eyise ekiragiro kanso Jeffrey Twamusima akwata application torture eno agireete mu kooti eno musobole okuwulirizibwa then ku bye nnaayogera kooti kweno esinziira omusango guno guwulirizibwe oba gugobwe ekitulo mulamuzi mbadde nsaba nga tetunaba kwongezayo musango application torture yange esooka okuwulirizibwa mu kooti eno era kijja kumbeera kizibu okuva mu komera okujja wano prison ejja kunzitirayo nesigenda kujja wano nga application temaze kuwulirwa emisango egyinvunaanibwa nze ewano bebanvunaana nabo F5 S6 sibamanyi sibalabangako ate kooti esoma Siwadammaike versus Uganda versus Siwadammaike ku nsonga zesimanyi zesirabanga zesikulanga mbadde nsa application
My advice to my client, even when the application is ready, is that the law allows us, the lawyer or the accused person or any other person who has been infringed of his right, to bring that during the hearing of the matter, not pre-hearing. The process we are doing now is pre-hearing. And after the pre-hearing, either confirmation or non-confirmation, I'll be very able to provide or to bring that application before court to the panel or one judge who will appear, who will be in charge of our matter. And I do pray that this Honorable Court explains it not to only him but to all of them, so that they can ably understand beyond my reasoning. I so pray.
ebigenda mu maaso byonna bino biyimirira basooke bampulirize olw'eddembe lyange lyebasemateeka tuli ku pre-trial kyemmanyi application torture esobola okuwulizibwa ku pre-trial tewali teeka werigambira nti pre-trial okutulugunyizibwa tekuwulirizibwa tulina kuwulirizibwa ku trial mbadde nsaba application eyo agiteekeyo mpulirizibwe then ebinaddirira kooti yeneesalawo.
In the ruling, Judge Alice Komuhanj halted the pre-trial hearing until Michael Serwada's torture application is heard.
I have also listened to Mr. Serwada Mike. He raises an issue of violation of the human rights, and specifically, he says he was tortured. I have looked at the law, and specifically, I have looked at Section 8 of the Human Rights Enforcement Act, and this is how it reads. Where in any proceedings in the High Court a question arises as to the violation of a fundamental right or freedom, the presiding judge shall immediately stay the proceedings and determine the questions raised. Counsel for the accused for A1 has submitted that this is a pre-trial hearing and he intends to file the application for violation of the human rights during the hearing in the event that the charges are confirmed. However, from the wording of the law, it states in any proceedings in the High Court. I believe pre-trial hearing is a proceeding, or there are proceedings before the High Court. I am therefore required to stay the proceedings until the issue on the violation of the human rights has been resolved. In the circumstances, therefore, I direct Mr. Twamusima to file the necessary application not later than the 4th of March 2024, those are 2 weeks from now, serve the prosecution by the same date, and prosecution, if you intend to make any reply, please do so by the 18th of March 2024, And if Mr. Turiamusima desires to file any rejoinder, you shall do so by the 25th of March 2024. I shall then hear the application on the 26th of March 2024 at 9:30 a.m. This therefore means that these proceedings are stayed pending the determination of the issues regarding violation of the human rights of A1. A1, A3, A4, and A7 are further remanded, while bail for A5 and A6 is extended till we determine the application. This gives time to Honorable Ssegirinya to also be treated, and so we shall come back after we are done with the application. Mr. Turiamusima, concerning the issue of disclosures, this court already made a pronouncement. Yeah, anything that was not served by the time I made that pronouncement will not be allowed on the court.
Court will resume on 26th March 2024 for physically hearing the torture application. The legislators co-accused have been further remanded.
We presented evidence of an admission of the Honorable Ssegirinya in the University of Amsterdam, and that he was under special care with a monitoring machine of all his organs as he processes facilities to enable him be fully admitted in Amsterdam. Unfortunately, before he acquired the necessary funds and facilitation from Parliament to proceed with his treatment, he was again admitted in Zambia Hospital. Unfortunately, Zambia Hospital did not manage the case of such a magnitude, which had been started with the University of Amsterdam. Upon funds being provided by Parliament for him to be taken to Amsterdam, again we got sad news that he was in such a state that he could not travel for long hours without life support. It meant an air ambulance. The budget so allocated to the Honourable Member of Parliament could not afford an air ambulance from here to Amsterdam. But the budget could afford a similar hospital which could manage in the interim his status before being flown to Amsterdam. It's the reason he's in Nairobi in the Aga Khan Hospital, being managed until such a time when he can be taken to Amsterdam to be attended to as advised by the doctors. So currently, we could not proceed on those grounds, and the court had to adjourn this matter. But most importantly, the adjournment that we received was not premised only on grounds of illness, the Honourable Ssegirinya. There's an issue which has come up since Masaka, when these people had been arraigned for the first time in the High Court of Masaka, when the ICD was at Kololo, through different judicial officers, A1 and others have claimed that they were tortured to give evidence against the Honourable Ssegirinya, the Honourable Ssegirinya. Court had turned a deaf ear and had other applications, even when it is very clear under the law. You cannot proceed with any trial the moment an accused person raises an issue of torture. Issues of grave torture, to push a co-accused to implicate a co-accused. This is the evidence that we are given in disclosures. Evidence from co-accused persons. Today, the court has closed the door. No more evidence whatsoever can be admitted. So we are left with such evidence of people who claim they were tortured. They have been granted an opportunity to present such torture cases, especially Serwada Mike before this honorable court before we proceed with any matters. So this matter has been stayed until such a time when matters of torture for accused persons turned or come witnesses.
Machinde West Member of Parliament Alan Ssegirinya, Kawempe North counterpart Muhammed Ssegirinya and 4 other co-accused are answering charges of terrorism, murder and attempted murder